In a landmark ruling, the High Court has found the Commonwealth should pay compensation to one of Australia's most prominent Aboriginal clans for the loss of their land. The decision triggering warnings taxpayers may now be forced to fund claims spanning a century of Indigenous dispossession. This story contains the names and images of people who've died.
This is the Gove Peninsula in remote northeast Arnhem land in the Northern Territory.
Traditional owners, as we know, have existed and, practising culture on that land for thousands of years.
In 1968, the Commonwealth Government leased the land to mining consortium Nabalco. The traditional owners were kicked off and their ties to the land severed.
That land was essentially sold off, and so they would have had dreaming stories related to that particular area. They would have had sites that they would visit and, carry out cultural practices and ceremony. Those rights were actually taken away and extinguished.
25 years later, native title was first recognised in Australian law in the wake of the landmark Mabo ruling that established Australia was not terra nullius or belonging to no one at the time of European settlement.
The High Court has recognised there were people here and their descendants have rights.
Native title recognises Aboriginal and Torres Strait Islander peoples' pre-existing rights to land and waters, the right to fish, hunt, perform ceremony and protect cultural sites. But to claim native title, traditional owners must prove they have an ongoing connection to land and continue to practice their culture there. Now, as the mining activity on the Gove Peninsula winds up, leaving the land destroyed, the Gumatj people have taken on the government and won in a landmark native title case.
Justice has been served in this country for my people.
Today is a victory for decency, common sense and the rule of law in this country.
The case was launched by the late land rights activist Dr Gumatj in 2019.
The mastermind of all is the one that had the vision of what is yet to come.
Central to Gumatj's case was while the traditional owner's connection to the land was destroyed more than 60 years ago, the government failed to act on just terms when they leased the land for mining. The just terms clause means the government must pay a landowner fairly if they acquire their property. The term made famous in the film The Castle, where a family fights to keep their home from being acquired despite the government's offer of compensation for it.
What are just terms when you've had your traditional country taken from you without your consent, when you've had your sacred places destroyed?
How do you put a price on cultural loss?
In 2023, the Federal Court ruled in Gumatj's favour that taking away native title rights is like taking property, so the just terms guarantee applies. The government disagreed and appealed.
Given the government has spent most of this term campaigning for the rights of Indigenous Australians, why did it appeal this decision about the rights of Indigenous Australians all the way to the High Court?
Because we made that decision that was in our interest to provide certainty.
The government says losing the appeal could open the door to claims from other native title holders beyond Arnhem land, large taxpayer-funded sums dating back more than a century for everything from roads to leases to buildings. But this week, the High Court upheld its ruling.
Native title recognises that Indigenous Australians have a connection with country, which existed and persisted before and beyond settlement. It is older and deeper than the Constitution.
Does that open the door for conversation, billions in conversation?
Oh, look, the decision is, of course, not a final decision. There'll be a whole court process arising out of this.
Estimated at around $700 million, how much compensation the Gumatj people will be awarded yet to be determined in court.
There's a huge opportunity here for Australia's government to work with us and walk with us. The economic opportunities are huge, so we look forward to what's next for the future for our people.
Author and history powerhouse Professor Clare Wright is an adopted member of the Gumatj family. Clare, you wrote a book on the birth of the land rights movement in Australia. Did you expect this result?
Oh, look, it was a knife edge. It's certainly a nail biter, and these days you don't expect much, but I got to say no, I didn't expect it. There were tears all around, a lot of calls with Arnhem Land backwards and forwards, and it's an extraordinary result. Just so happy for everybody involved and all the members of not only the Gumatj clan but the other Yolngu clans, Baparu, who have been fighting now for over 60 years for their land rights.
So do you think we'll see other groups pursue similar claims to this?
It's quite possible. I don't know. Every aspect of this law, I'm sure, will be tested and played out under its own merits. I mean, it's not like these are the only people who have had their land taken from them. That did not happen under just terms, and who will be able to be justifiable in their claims for compensation for damages done over the time in which land was taken and used in a manner that has been destructive to local communities.
The government could be liable for hundreds of millions to the Gumatj people. Are you worried, Claire, that they might not see that money?
I know where you're coming from on this. There is always that, but how will it change things on the ground? Who will actually be the beneficiaries of this? But I think that gets us into a kind of negative narrative around what happens when compensation is paid by the government to First Nations communities. And I don't want to even scratch the surface of that negative narrative, because this is not the moment for that. This is a moment for absolute celebration.
So to you, is the real benefit of this the decision that has come down in principle more than the financial?
I think it's a decision in principle. I think that is what was absolutely fought for. And the compensation aspects, well, obviously, if you have lost something and it has been proven that what you have lost has actually been stolen or taken from you, not on just terms, you should be compensated. All of us would expect that. How it actually plays out in terms of what compensation is due to the Gumatj people, well, we'll wait and see how that goes.
Claire, sadly, Yunupingu passed before the judgment was handed down. What do you think this victory would have meant to him?
What I know is that he will be smiling somewhere about this. But he did say to me that he has seen every Prime Minister since Gough Whitlam, and every single one of them had made promises. Every single one of them had determined to do better, and every single one of those promises was broken. So this is a moment, I think, where to have the federal court and then the High Court determine in his favour is a moment of extreme vindication for a lifelong project for justice for his people and for all First Nations people in Australia.
It was a long-fought battle, but finally he has his victory. Claire, thank you so much for your time tonight.
Cheers.